the revelations and allegations at the State Capture Commission are true, it's fairly easy to accept that we are indeed in a crisis. Over the years, many auditors have been accused of colluding with companies to enable state capture. Well, joining us now to discuss how the sector is turning the corner is Rebecca Motsepe, who's the Executive Director of Legal at the Independent Regulatory Board for Auditors. Rebecca, good evening, and thank you so much for your time then tonight. Let's talk about this amendment to the Auditing Profession Bill. What exactly does it incorporate that might see some of the things that have happened in the auditing profession, perhaps that will make it difficult for it to go unnoticed?
Evening, Kathy, and evening to your viewers. Thank you so much for inviting us this evening. Well, we are ecstatic that the Auditing Profession Act has come a long way. And as we all know, it has actually been supported by both the SCOF and National Assembly very recently. The key issues, I think 5 of the key issues that we are excited about in relation to the amendments, specifically in relation to strengthening the IRBA's powers, is the fact that it seeks to strengthen the board's powers or independence by removing or ensuring that we do not have registered auditors in our board members. We don't have registered auditors within the disciplinary committee, and we don't have registered auditors in the investigating committee. This will ensure that our board is independent and thus ensuring that the credibility of decisions made by the board. Also, it ensures the strengthening of the investigating processes. We all know that over the years, the IRBA has been rather questioned on the credibility or maybe the speed of the investigation processes. Now, what the bill proposes is that it gives the IRBA powers in relation to subpoena, which will enable the investigating committee to subpoena certain pertinent information or documentation relating to the investigation processes. It also provides the investigating committee with search and seizure powers, which is a biggie in relation to investigation processes, which enables the IRBA or the investigating committee specifically to enter premises and seize information that is relevant or pertinent to an investigation that is ongoing. This will help us a lot in that it will speed up our investigation processes where we do not have back and forth correspondence between us and the auditors under investigation with regards to documentation. Most importantly, it also seeks to ensure the efficiency of our current disciplinary processes in ensuring that our processes are more agile in nature. It creates a big pool of the disciplinary committee in that from which the IRBA can then appoint at least 3 members to hear particular disciplinary hearing. Now, this is a big one for us because currently the IRBA Disciplinary Committee consists of 11 members and 6 of which constitute a quorum, which means at any given point in time, we can only have 1 hearing going, which means we sit with a backlog or a number of hearings that are not going forward. So this bigger pool of disciplinary committee will ensure that our matters go before the committee with a certain level of speed, and we get to the conclusion of such matters quicker, ensuring that errant auditors are dealt with appropriately and timelessly. It also, and this is something that we've been calling for a while, it also removes the link between monetary sanctions that can be imposed by the disciplinary committee and or the IRBA in respect of improper conduct. It removes the link to the Adjustment of Fines Act, which currently limited the monetary sanctions that could be imposed to 200,000 rands per charge. Now, this has been said to be, and we believe it's quite lenient and it's not effective as a sanction. It does not serve as an effective deterrent for improper conduct. So now it has removed this link and empowered the minister to determine what would be appropriate sanctions. So we are now hoping that this would bring much more heavier sanctions, which would have the deterrent effect that we are hoping to achieve. Also, it enables the IRBA to refer non-audit matters. You will note most of our auditors or most of our stakeholders know that a majority of our matters are non-audit matters. This now clogs up most and takes up most of our resources in relation to the investigation and disciplinary of matters. So what the Act now allows us to do is to refer such matters to our registered professional bodies, and to focus our resources on audit investigations or audit matters, which therefore means that the effect of giving effect, the giving effect of our mandate, our primary mandate in terms of the Act, which is the protection of the investing public who rely on audit work, we will be able to speed up the process in that regard. So those were the key changes that are brought by the amendments.
And where are we now in terms of the finalization of the process of this amendment bill?
Well, Katie, the amendment bill has been supported by the National Assembly following SCOF's approval. The bill will now go to NCOP. We're hoping that it will be going to NCOP next year early, and then we'll go back to National Assembly for final approval. We're hoping that all this process will be finalized in the first quarter of next year. On the IRBA side, we are already in the process of crafting our implementation plan and ensuring that we have processes and sufficient resources to ensure the implementation of the amendments as soon as they come into effect.
And how soon are you going to be able to do this? So are you waiting for the parliamentary process to be concluded before you start making some of the changes to your organization?
Well, Kathy, for most of the changes that are coming up, unfortunately, we can't start implementing them until the amendments come into effect. But what we have started doing is putting measures in place to ensure that when the amendments come into effect, relevant documents like the amendment of our rules, the amendment of board processes, the constitution of disciplinary committee members are already in place and can just sit before the board for consideration and approval. So we have through the various departments within the IRBA, tried to ensure that we start the process so as to the minute the president signs off, we are in a position to give effect to these documents.
How much of this process has come as a result of the attack that, you know, IRBA, including other institutions that represent auditors, that you took, especially as a result of some of the wrongdoing that has been pointed to, where auditors have been named as having played a central role in allowing or in creating room for that wrongdoing to take place?
Well, I think, Kathy, we can honestly say that the amendments to the Act has largely been as a result of our response as part of our Restoring Confidence strategy, which the IRBA put in place in response to all the audit scandals that have come to the forefront in the prior years or prior months. And so this is one of a biggie in our Restoring Confidence strategy. The project was initiated as a result of that specifically, so as to enable us to restore confidence, not just in the IRBA as a regulator, but in the profession, to ensure that there is confidence not only in the markets, but also in the work that is done by our auditors. So I think it's fair to say that the amendments were prompted by everything else that has come to the forefront. But even before that, it's important to note that the IRBA has always been alive to the shortcomings. And we all know that legislative amendments is quite a process. It takes time and it takes deliberations. This particular process was already started in 2018, and we are only seeing an end to it now or in the early 2021.
All right, Rebecca Motsepe is the Executive Director of Legal at the Independent Regulatory Board for Auditors.